Oyez, oyez. The Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good afternoon, everyone. Is my microphone? My name is Robert Montgomery. I'm going to be the presiding judge of this panel of the Court of Criminal Appeals for the January 2025 docket. We appreciate the invitation of the University of Tennessee Law School to be here. And in fact, you have three judges on this panel that all graduated from law school here. My name is Rob Montgomery. I'm Sullivan County. To my left is Kyle Hickson, who is from Knox County now. I guess you claim Knox County.
Yes, I do.
Knox County. And to my right is Tom Greenholtz, who is from Hamilton County. We have three cases that are set for oral argument this afternoon. And if you enjoyed today, you also have the opportunity tomorrow to come down and watch us at the Supreme Court building on Main Street in Knoxville. We'll have another 6 cases then, so we'll be there both tomorrow afternoon and tomorrow morning. As always in appellate cases, each of the parties will have 20 minutes to give their argument to the court. If you're the appellant and wish to reserve any time for rebuttal, please let us know. Of course, we have an electronic timer on the bench that should help you, or on the podium there, to help you know where you are with your argument. At the end of this afternoon's argument, after all three are done, we will remain, and we ask if the counsel would like to remain, and any of you who would like to remain, we'll be more than happy to take questions from you about what it is we do or how we came to be on the court. And other questions about in general. But you don't get to find out how we're going to rule in the case that you heard today because we haven't made that decision yet. We won't do that for probably at least 2 or 3 months, at least a written decision. We'll probably have a pretty good idea after today is over, after we deliberate after oral argument as to how we anticipate that the case is going to be decided, but we won't do that until we've had an opportunity to write the opinion.
No, I appreciate the opportunity to be here. As Judge Montgomery said, we're all graduates of the Taylor College of Law, and it is a thrill to be back here. I was telling Professor Barkoff that I don't think I've set foot in this building since I graduated. My fault. Except for maybe a couple of times since then. And so just to be back here is an extreme honor for me. And so thank you all for having the court down here today. It's my pleasure to be part of the panel. Thank you.
Yes, thanks for having us. Go Vols, beat Kentucky.
Okay, Madam Clerk, there you are. Do you have any? Or we have any preliminary matters?
No, Your Honor.
All right. You wish to call up the first case, then, please.
State of Tennessee versus Michael Flamini.
Okay.
May it please the court, my name is Jonathan Harwell. I'm here on behalf of the defendant appellant Michael Flamini. I've asked for 4 minutes for my rebuttal time.
All right, thank you.
I've raised 3 main issues in the brief. I'd like to discuss 2 today, the suppression issue and the forfeiture issue. The mistrial issue, I believe, is a strong issue, but I don't have anything else to say. I think it's fleshed out in the briefing itself. Would like to begin with the suppression issue, just to remind the court of the facts of this traffic stop. In very brief, it was a stop for an expired temporary tag. We don't have a quarrel with the initial stop. Mr. Flamini pulls over appropriately to a store, parks. The officer approaches, asks him to roll down the windows, asks for his license. Mr. Flamini says, I don't have no license. He says he doesn't have other identification with him. He says the car wasn't stolen. Officer then says, well, are you on probation or parole? He says, no, I did just get out of prison. Officer says, what'd you get out of prison for? He says, robbery. At that point, really a very few seconds have gone by in this interaction. The officer asks him to step out of the car. As he is stepping out, the officer pulls the door open, takes hold of Mr. Flamini, turns him around, immediately puts handcuffs on him, and then immediately moves to an intrusive pat frisk. It is during the course of that pat frisk, as you can see from the body cam video and it was testified to at the hearing, the officer is, as he is pat frisking Mr. Flamini, he sees into the car and believes he sees contraband that then sort of justifies the things that flow from that. A little bit unusually, I think it's helpful at this point to go through a touch of how this issue was presented, decided, and now is being presented on appeal, because it has changed. There was a motion to suppress
Mr. Hartwell, before we begin, can you tell me what the issue is, please? And the reason I ask that is, are we talking principally that the extraction from the car is the issue? Are we talking that the pat and frisk, you know, the Terry search is the issue? I understand you're saying it all flows together, but what's the first Fourth Amendment issue you think we have to confront?
The first Fourth Amendment issue is not so much asking out of the car, but pulling out of the car, holding on to him, putting the handcuffs on him, and the pat frisk. All of those things happen essentially simultaneously, and all of those happen before the officer testifies he sees the suspicious item in the seat of the car.
Okay, so with that, do you contend that the request to come out of the vehicle was improper?
No.
Okay, so the officer had the ability to ask the driver of the vehicle to come out. And then with that settled, the Fourth Amendment issue then is placing him in handcuffs?
He has the ability to ask him to come out. He doesn't really, what he says come out, and then he kind of pulls him out.
Okay.
But as he is pulling him out, he is turning him around and putting the handcuffs on. It's
Okay.
all sort of at the same time.
With the driver out of the vehicle, and with us all now agreed that the officer could ask him to come out of the vehicle, would not the contraband inside of the vehicle then been in plain view?
There's no evidence that it was. It was in plain view. He viewed it at the time, I think this is clear from the record, at the time that he is, we would say, improperly arresting and pat frisking Mr. Flamini. At a time when he is, the door is open because the officer has pulled it open.
Has asked him to come out of the car, the driver to come out of the car, so could
And
the
has
officer?
pulled the officer pulled the car door open and kept it open.
Okay.
As he is doing the pat frisk, that is when he is able to see in and see the item.
Okay, so with the driver out of the driver's seat and the door open, would the officer have been able to see the contraband inside of the car in plain view?
We don't have any evidence
mean-
as to that.
Okay, I mean, no evidence, oh, you have photographs in your brief. It looks to me like the officer could have seen the contraband in the car with the driver removed and the door open. Is that not true?
It's possible. I do think that the door still being open is a problem, in that so MIMS, the idea of asking someone at a traffic stop to step out is, I don't want to be shouting through the window, but you come out and we can have a conversation about what's going on. And I think that presupposes someone getting out on their own power, close the door if they want to, and then have a interaction. What happened here is, I want you to get out, and I am opening the door, grabbing you, pulling you out, making sure the door stays open, patting you down, and now I see it. So I don't think it's a plain view situation. And importantly, and this sort of maybe dovetails into what I was about to get to, the state's never argued it was plain view. They've not argued it was plain view in the trial court. They've not argued it was plain view on appeal. The justification suggested by the officer and adopted by the judge in the trial court was this was a pat frisk for a Terry stop for officer safety. I think the state has, Mr. Ward may disagree with me, the state has essentially changed its argument on appeal. This is not now addressing was a reasonable suspicion Mr. Flamini was armed and dangerous. The state now contends this was a custodial arrest and a search incident to arrest. I submit that is the argument the state has presented, and the one that is ripe for decision by this court. Where the state goes wrong, in my evaluation, is goes to the issue of whether the offense that the state says Mr. Flamini was being arrested for, which was driving without a license, whether that is a citable, a cite and release statute, or is that an arrestable issue. Tennessee Supreme Court has said that 47-118, the cite and release statute, actually creates a presumptive right to be cited. And if that cite and release statute is violated, if officer conducts a custodial arrest for a citable offense, that what flows out of that is subject to suppression. And we contend that is what happened here.
So there are a number of exceptions to that statute the state relies upon too. Would you address those for us, please?
So again, I think we're complicated in that this is new on appeal. So there was no evidence, I submit, that was developed in the trial courts to support those. The state never argued those. But the record as it stands does not support those. The two that are relied upon in the Jackson case is, one, there's a reasonable probability the offense is going to continue. And officer never suggested that was the case, that he was worried that this defendant was going to continue to drive without a license.
Well, if he cited and released him, he absolutely would continue to be driving without a license. Is that correct?
Not if he didn't drive. I mean, he is parked in a location that's off the road. And interestingly, even though no one was focused on this, the evidence actually establishes that his significant other shows up at the scene and drives the car away.
If she drives the car away, is she not also committing the offense of having the license tag be expired or not valid? My understanding is that the car itself also had expired license tags, and that may have also been the reason perhaps that it was pulled over. So even if the officer cites and releases him and she takes her own car, is she still not also continuing to commit an offense?
That's a good point, Your Honor, although, again, the state hasn't raised that. Maybe she has the proper tag for it, or maybe she can arrange for permission for it to stay at that spot. This is not a situation where you're on the side of the highway that somebody's going to have to drive the car away. Again, because of the way this was argued, we simply don't have evidence on that point because no one was claiming that was why this was okay. The second point is that the second possible exception is the absence of ability to know who Mr. Flamini is. Again, officer didn't even ask him his name before he puts handcuffs on him. But Supreme Court in Walker has, if I'm remembering the case correctly, yes, Walker has talked about even if you don't have picture ID in this age of computers, and particularly when Mr. Flamini said he'd gotten out of prison, he could have provided information, or at least the officer had a duty to try to find information that could have verified name, address, social security number, DDoC number, that he could have verified his identity. He made no effort to do so. And so I think the state's reliance on that exception to the cite and release statute, again, is simply not proven. If I could turn, with an eye on my time, turn to the forfeiture issue. This, we claim, is a violation of Mr. Flamini's constitutional rights, his essentially his Fifth Amendment due process rights, in that after the nature of the right is that after you are arrested, after you're provided with Miranda warnings, you have the right to remain silent, and you have a right for that. Any silence that you choose after that point can't be used as substantive evidence against you. And that is from Wainwright versus Greenfield, U.S. Supreme Court. The proof that the state was allowed to introduce at trial over repeated objection of the defendant, the proof it was allowed to introduce sort of had two parts. First was the testimony of the arresting officer, in which he talked a little bit about the forfeiture process that he initiated. He filled out some paperwork to take this $880 that was found on Mr. Flamini's person. And he explained the process that he would present this information to a magistrate who would essentially make a probable cause kind of determination, and then the process would go forward. And he said that, or was asked by the prosecutor, defendant is given the opportunity, if he shows a legitimate source of where that money has come from, he can get that money back. Officer said yes. So he sets up this process, that there's a forfeiture process that ultimately, if you show a legitimate source of your money, you can get it back further down the line. The state was then allowed to introduce as an exhibit, which is in the record as Exhibit 10, the ultimate forfeiture order issued by the Department of Safety. So this comes about 10 months later, and that forfeiture order, in addition to forfeiting the money, it says that this proceeding was begun and that no petition was filed, and therefore the money is forfeited. So what the state, the jury has been told is $900 at issue. If Mr. Flamini had a legitimate source for that money, he would have been able to try to present that and get it back, and that no petition was filed. Essentially, no effort was made. And the state, I think, in talking to the judge, was fairly clear that what they were wanting to show was the defendant had an opportunity to get the money back by showing a legitimate source, and he didn't do so.
So on appeal, though, your friend on the other side, if I understand the argument correctly, is that essentially the defense opened the door to otherwise perhaps inadmissible evidence. That the defense questioned the investigating officer about what he was able to determine through his investigation about the source of the funds and whether additional investigation could have been forthcoming. With defense counsel having opened the door, I think your friend then suggests that the source of the funds now is fair game, and that evidence that the defendant is not claiming that there's another source is therefore then relevant. What's your best response?
I think I have two responses to that. One is it's a different issue. It's not a opening the door. There was no issue that was there was issue being made at trial by defense counsel about the adequacy of steps that the individual officer was taking. Proving that 10 months later in a sort of quasi-judicial proceeding, the Department of Safety decides to forfeit the money because no claim has been filed by the defendant, in my mind, that's a different issue. It's a different door. It's not behind that same door.
They're both related to the source of the funds, though, right? And the source of the funds is relevant for the crimes that he's being charged with and being prosecuted. So if both of those issues relate to the source of the funds, why is the state's argument incorrect?
Well, I think that the second thing I would say is, as I understand it, the idea of opening the door is essentially one of relevance. That we have a trial that is limited to certain issues. By the actions of defense counsel, we have expanded the issues, and now evidence that previously was not relevant may now be relevant.
Or evidence that previously was inadmissible is now admissible.
I'm not sure I agree totally with that, in the sense that we have. I think it's about relevant being expanded, but it is not about
proportionality. You have a proportionality requirement. True.
It is not about evidence that is constitutionally prohibited becoming allowed. I mean, and I tried to say this in my brief. I think, as a matter of relevance, the fact that Mr. Flamini didn't try to get his $900 back, logically, that is always that is relevant. Like, that's common sense says if you had a good explanation for your $900, you'd probably tell somebody and you'd get it back. The problem isn't one of relevance. The problem is Constitution says it doesn't work that way. When he has been told after being arrested through Miranda, he has the right to remain silent. He has the right to remain silent. And that silence, even if it's relevant, even if we always think, if I was in that position, I would have spoken up, that is not something that can be used against a defendant, and it was used against him here. So
the argument is not without persuasive force, but let me see if I can take it one step further. Is the argument really that I have a constitutional protection and that I can come close to waiving that constitutional protection by putting this fact at issue. I can have my lawyer question state's witnesses about it. I can put the source of funds at issue in, but when it comes to this one piece of evidence, the Constitution prohibits me from waiving that, and it must always trump anything else with regard to proportionality or relevance. I mean, is it really that broad? And can the defendant, let me phrase it another way, Mr. Harwell, maybe that wasn't very clear. Is the defendant privileged under the Constitution to say, I want my lawyer to go question and make this an issue, but I also get to prohibit the state from coming back and explaining other parts of the issue as well? Does it?
I'm trying to make sure I don't say anything misleading, but I think the answer is yes.
Okay.
I mean, the states cited one case, I don't remember, a United States Supreme Court, where there was a specific argument at trial. Defense counsel said, my client wasn't allowed even at trial to explain his side of the story, and the prosecution got up and said, well, he could have testified. So in that way, you can affirmatively waive use of your silence against you. This is a long way from that. It was inevitable in presenting the defense to this case that the defense counsel was going to suggest, we'd have to suggest that $900 doesn't necessarily come from drug money, because otherwise he's guilty. But just raising that kind of issue that, yes, it could have come from lots of other places, doesn't amount to a constitutional waiver that would allow his pre-trial, post-arrest, post-Miranda silence to be used substance evidence against him. And I will reserve the rest of my time for rebuttal.
Okay, thank you. General?
Good afternoon, Your Honors. May it please the Court. Garrett Ward on behalf of the State of Tennessee in the matter of State versus Michael Flamini. Your Honors, like my friend on the other side, I will devote my time before this Court chiefly to the suppression and the Fifth Amendment issue, and I'll rely on my brief for the mistrial issue, as Mr. Harwell did. Starting with the suppression issue, Your Honors, the trial court properly denied the defendant's motion to suppress, and this Court should affirm that denial for I'd contend two separate but legally sufficient reasons. And I'll start by sort of briefly discussing the facts, because I do think that, unlike in a lot of suppression cases, there's a good deal of agreement between the parties as to what happened here. I take the parties to agree that the initial traffic stop here was proper, that the officer, Marasegan, observed the defendant driving a car with an expired temporary tag, lawfully pulled him over at that point. That Officer Marasegan then, during the course of this traffic stop, which happens, it looks to be from the body cam video in a parking lot of a convenience store, that during the course of this stop, Officer Marasegan asks a number of questions of the defendant that he is entitled to ask. So there are no questions or concerns about the propriety of the initial stop, and as I understand my friend's position, there are no questions or concerns about the propriety of the initial questions that Officer Marasegan is asking of the defendant. Where I take our positions to diverge is when Officer Marasegan's response to the questions asked by the defendant is to get him out of his car and place him in handcuffs and then pat him down. Was that proper under the Fourth Amendment? And it's my contention before this Court is that it absolutely was. Critically,
well, it also seems like you both agree that it was proper to ask him to come out of the car.
Yes, Your Honor,
Okay.
we absolutely do.
I thought that was a pretty significant concession, frankly, and this is why. I thought that under MIMS, the triggering fact to ask someone to come out of the car was the need to have the occupant out of the car for officer safety. And I thought that if there is a concession in that regard, it's because we have someone who's been previously convicted of a violent offense and someone who is volunteering without any prompting that the car's not stolen. And so with that, I thought, okay, that makes sense that we would be conceding the issue because the officer would have some concern as to his safety with those two facts.
Mm-hmm.
Add the fact that you don't have an ID, maybe that adds to it as well. I don't see how that dovetails then, and maybe you'll help me with this, with the pat down, because the pat down also, I thought, would also be justified by concerns of officer safety. Maybe so with the handcuffs, and I wonder about that. The officer probably could have placed the defendant in the back of the patrol car. He was the only officer on the scene. Placed him in handcuffs to make sure that the accused was not otherwise posing a danger to officer safety. Can you explain to me, please, what facts would have reasonably, objectively given rise to concerns about officer safety, as we have it here at the time that the accused is being pulled out of the car?
Certainly, Your Honor. And to some extent, in Your Honor's question, you mentioned some of the facts that we pointed to below and that we point to in our brief, underlying sort of our reasonable suspicion argument that would have supported the Terry style pat down. I think the facts I would principally point the court to are first this unprompted, unrequested, what I'll term just sort of odd profession by the defendant that, by the way, this car isn't stolen. That is, I believe, immediately followed the defendant saying that he's very recently been released from prison for as Your Honor noted, a violent offense, and then at the same time is both unable to furnish a driver's license or any other type of identification on request. So I think a combination of those facts, coupled with as Your Honor noted, the fact that Officer Marasegan is the only officer on the scene. This isn't a case where there's 2 or 3 cars conducting a stop at once. That looking at those facts sort of in total, we have there is reason for Officer Marasegan to be concerned about officer safety. I think in MIMS, the U.S. Supreme Court specifically notes that there is a fairly high degree of safety concerns when it comes to officers interacting with persons who are, sort of alone in vehicles. I know that MIMS directs that inquiry mainly to asking the officer to get out of the car, but I think to some degree it carries through here. There is some degree of inherent risk always, and then when you couple that with some of the facts I've just discussed with this court, I do think that that supports the notion that there was cause here to do a Terry frisk of the defendant, and the parties do seem to agree that it's during the course of doing that pat down is when the drugs are initially discovered.
The ones that are discovered on his person.
Yeah, there are drugs. Yes, yes to the ones on his person, and then I believe that it's also as that's being conducted that the vial is seen in the car. The record is a little unclear from that. This court will be able to view 2 versions of this body cam video. But what it seems happened is that as the pat down's being conducted, Officer Marasegan finds, sort of feels the drugs, and then, unless I'm misremembering the record, in which case I would absolutely yield to the record on this point, at the same time sort of notices a vial containing something he believes to be heroin upon seeing it. So I would contend to the court that there's reasonable suspicion. However, there is existent in this record an entirely separate and entirely sufficient basis to affirm the denial of the suppression motion here, and that's that at the time Mr. Flamini is taken out of the car by the officer and placed in physical restraint, is handcuffed, that he is in fact arrested, and obviously under the search incident to arrest exception to the warrant requirement. If Mr. Flamini has been arrested, the officer is entitled on that basis to conduct a search of the area sort of immediately around Mr. Flamini's person, which would encompass the car, and Mr. Flamini has set himself.
What was the crime for which he was arrested?
Driving without a license, Your Honor.
Was he actually arrested for that?
Your Honor, I would contend that yes, he absolutely was.
Well, what was the record of the suppression here? Because a search incident to arrest may apply if, in fact, the accused was placed under arrest at the time. You're suggesting that the hearing on the motion to suppress indicates the fact of an arrest at the time, and it was for the missing driver's license?
Your Honor, what I would suggest to the court that what the facts in this record show are that at the time he's handcuffed, he meets that set of facts objectively meets the standard for what constitutes an arrest that this court pointed to in the Smith case and that the Tennessee Supreme Court pointed to in Bishop. The Tennessee Supreme Court discusses 3 requirements. One is sort of the base seizure requirement, that a reasonable person in the defendant's shoes wouldn't have felt free to leave, which is clearly met here. The second is sort of actual physical restraint, which is also, I think, clearly met here. He's actively handcuffed. And then the third, is there a sort of a legal basis at that time to arrest him? That we look to those three facts, and if all of those three facts are present, that there is an arrest in spite of whatever subjective intent the officer taking these actions may have had at the time.
Was that argued below, though, by the state?
Your Honor, the state below defended against the idea that suppression was proper. Our argument below was mainly focused to sort of the first point I raised before this court regarding reasonable suspicion.
Well, if you're raising search incident to arrest as a justification at this point, aren't you changing theories on appeal?
Your Honors, the state is presenting to this court two different arguments, but the state's primary issue, which is sort of where I take Your Honor's question to maybe be going towards waiver. Primarily, when we're thinking of waiver in terms of things being raised below, we do look to whether issues have been preserved, and the issue of suppression here was squarely placed before the trial court. Yet the state's argument has certainly, to some degree, changed from below to now, or I'd say been added to at the appellate level. But I don't see waiver here, and from my understanding of Mr. Harwell's reply briefing, he is obviously free to disabuse me of this notion during rebuttal. I don't take Mr. Harwell to outrightly be saying that the state is sort of precluded or prohibited from advancing the search incident to arrest position. I take him to be saying that there are perhaps some evidentiary difficulties that are posed by this sort of additional argument, but I don't take there to be a real assertion that the state's position has been waived, because the principal issue here was squarely placed before the trial court.
General, is it the state's position that there was an actual arrest for driving without a license, or that the circumstances were reasonably consistent with an arrest?
Your Honor, the state's what I would say to that is that under, and I'll apologize if I get the verbiage from Bishop slightly wrong, or perhaps it's the verbiage from Smith. The state's position is that the defendant was clearly arrested here because those three facts pointed to in Bishop were met. That is an arrest in fact, despite whatever subjective intent the officer may have had at the time or may have tested to at the suppression hearing.
Okay. So the state's position is that if the officer did not subjectively intend to arrest the defendant, but merely restrained him because of officer safety issues, that because objectively what you have amounts to an arrest, that the Fourth Amendment exception for search incident to arrest will apply.
I think that's reasonably fair, Your Honor. Okay. I'll note that the state didn't create this position out of whole cloth. That is almost exactly what the holding in Smith is, and that's almost exactly what Bishop indicates is proper in this sort of inquiry, that what controls isn't the subjective intent of the officer, because frankly, the officer, when he's testifying at the suppression hearing, is fairly clear that he's doing this for officer safety purposes.
In fact, he never charges the defendant for driving without a license.
I believe that to be correct, Your Honor. But importantly, this court and the Tennessee Supreme Court have just essentially described that testimony as wholly irrelevant to the inquiry of was there an actual arrest, or at least enough of an arrest to not to bring us within the search incident to arrest exception.
Is it not an issue, though? I mean, especially post-Bristol, and the Supreme Court's emphasis there that we are courts of appellate jurisdiction only, that the state is now raising this search incident to arrest justification. It failed to do so, albeit the district attorney representing the state at that point. It failed to do so when it could have in the trial court, but now it is asking this court to pass on a question and a theory that was never presented to or ruled upon by the trial court. Mm-hmm. Is that problematic, especially after Bristol?
I don't think Bristol poses a problem here, Your Honor, because as my understanding of Bristol goes, what Bristol really demands is that the parties on appeal have a chance to make
Yeah,
their
and I'm not
arguments to
talking
this
about
court. And certainly.
the black letter of Bristol.
Sure.
I'm talking about the spirit of Bristol, that we only hear appellate issues. But in this instance, the state would be asking us to rule on an issue that was not presented to the trial court.
What I'd say to that, Your Honor, is that the state is presenting not a different issue before this court, but is making a different argument in favor of denial of suppression.
So could
That
the defense now challenge the constitutionality of the initial stop on appeal? I mean, suppression was before the trial court, so could they argue that on appeal?
I think the difference there, Your Honor, and maybe I'm trying to make too many angels dance on the head of a pin, but I think there would be a qualitative difference there because we'd be putting two different sort of substantive suppression issues before the court. One would be, as a matter of Fourth Amendment law, one issue would be this stop never could have occurred. The second issue would be as at some point during the stop, something violative of the
How
Fourth
is
Amendment
search
occurred.
incident to arrest, though, not a substantive area of Fourth Amendment law?
It's certainly a substantive area of Fourth Amendment law, but it's, the state's argument here is simply responding to the factual scenario of what occurred. The defendant is pulled out of the car. Below, he says that this violated the Fourth Amendment. The state below offered an argument based on reasonable suspicion that I still fully stand behind here on appeal. I hope my brief didn't make it seem like I was abandoning that. So the state's, if the issue below is did we properly discover these drugs? The state made an argument below based on reasonable suspicion, and within that same issue is making a different argument now. And I would contend to this court that avoids waiver issues, even those posed by sort of the spirit of Bristol.
General, can I go back then to
Certainly,
to
Your
the
Honor.
substance of it? If I'm reading it correctly, State versus Ingram, which is a Supreme Court case from 2011, Tennessee Supreme Court, our Supreme Court says it is not sufficient that an arrest could have been made. The arrest must have been made, roughly contemporaneous to the search, in order to justify it. And then in Crutcher, cited also in Ingram, the Supreme Court says that the subjective intentions of the officer are relevant to the inquiry, and that they're not dispositive of the issue, but they're clearly relevant to it. And so let me go back again to what my supposition or what my concern was. Is the defendant actually placed under arrest here for driving without a license, or is the state arguing simply that he could have been, and that therefore the search incident to arrest exception to the Fourth Amendment is applicable? 'Cause it looks to me like the officer said he was not under arrest at the time.
And that is certainly what the officer said at the suppression hearing, Your
So
Honor.
if Ingram is saying that it's not enough that he could have been placed under arrest, but that he had to be placed under arrest,
Mm-hmm.
how is your position consistent with Ingram?
Maybe we have here a bit of a difference between the way Bishop and Smith and Ingram, and I believe Crutcher was the other case, Your Honor,
Right. Yes, sir.
have described the relevance of the officer's subjective intent. I would, obviously, as I did in my brief, I would point this court to Smith and Bishop that have said it isn't relevant, because I do think, if subjective intent does matter, even if it's not dispositive, even if it's not relevant, then the state's position probably is something a little more similar to, or starts to look a lot more like, well, this is sort of like an arrest, so the search incident to arrest exception would apply. To be clear with this court, the state's position is that under binding precedent from the Tennessee Supreme Court, Bishop, and the sort of as this court construed it in Smith, although I'll note Smith is unpublished, that the subjective intent has at least been described by the Tennessee Supreme Court as not only not being dispositive, but as not being relevant.
What's the state's second best argument that the search is sustainable?
My second best argument would probably be the first argument I made before this court, that reasonable suspicion does, that there was a possession of reasonable suspicion that would have triggered the sort of Terry stop and frisk.
There was reasonable suspicion that the defendant posed a danger to officer safety. The officer could have searched the defendant. In the course of searching the defendant, the officer discovers contraband.
Yes, Your Honor.
Okay.
What about the handcuffs, though? I mean, it may be one thing if you get him out of the car and you have reasonable suspicion to do a Terry frisk, but it's my understanding he pretty immediately handcuffed Mr. Flamini. Am I accurate in that reading of the?
It's pretty quick, Your Honor.
And would the state concede that that is a full-scale arrest for Fourth Amendment purposes?
I believe so, and Your Honor, one of the state's primary positions before this court is that it was a full-scale arrest for Fourth Amendment purposes, triggering the search and incident to arrest exception.
Based upon the driving offense, or
Yes,
the
Your Honor.
licensure offense, I should say.
Yes, driving without a license.
Okay.
I'll briefly address the second issue related to forfeiture, and I think where I have to start my discussion of this issue is that it has been waived. There was not an objection made on right to silence grounds contemporaneously below. I know my friend on the other side disagrees with that, so I do believe it's been waived and it's reviewable solely for plain error. But in the interest of time, because I see I'm running a little short, I'll sort of jump to the merits, because really, whether we're on plenary review or plain error, this court's analysis and decision making should look pretty similar, because the forfeiture order itself and the brief bit of testimony the jury does get about it from Officer Marasegan, the door was open to this evidence and testimony, to this exhibit and testimony, by the way the defendant chose to cross-examine Officer Marasegan at trial. The state does not introduce this forfeiture issue. This forfeiture order doesn't discuss the forfeiture process in its direct examination of Officer Marasegan. During cross-examination, time and again, the defendant asks questions of Officer Marasegan that create in the mind of the jury the conception that Officer Marasegan made no attempt to look into the provenance of this money, that Officer Marasegan didn't ask any questions about it. Essentially, the idea you get from cross-examination is that Officer Marasegan just didn't care. And this does open the door to evidence showing, speaking at least somewhat to the depth of Officer Marasegan's.
Now, your friend on the other side, and I know we're out of time, but your friend
Certainly.
on the other side essentially raises this prospect, that this is an issue at trial. Defense counsel's bound to question about it because it's relevant to the offenses. And if opening the door comes not from the defendant's testimony, but comes from merely the questions of counsel, the defendant's in a catch-22. Defendant can't properly cross-examine on issues that are relevant to the offense without implicitly waiving constitutional protection. So what's the best response to that?
My best response, Your Honor, is that it's certainly not the state's position that there was no way to address this issue without opening the door. The state's position is that these specific questions, though, did open the door. At the risk of using overly dramatic language, what defendants are certainly not entitled to do is look at a piece of evidence that is of maybe perhaps questionable admissibility that the state has not introduced, look at testimony related to that evidence, and then ask questions that seek to create the perception that this evidence, that this testimony, that this exhibit does not exist. That I think it's Robinson is the case. I'll point the court to it. It's cited in my brief.
That's fair, counsel. I appreciate the answer.
That deals roughly with this, but that'd be my best response to it.
Okay, thank you. Thank you, Judge.
If there are no further questions, I would ask that you affirm. Thank you, Your Honors.
Mr. Harwell?
I have three brief points I'd like to make. One is the first two are related, going to the reasonable suspicion and the Terry stop issue. I think to clarify the idea we were discussing, plain view applies when officers are otherwise acting lawfully and they see evidence, the incriminating character of which is immediately apparent. It is our claim that Officer Marasegan sees the first bit of contraband at a time when he is acting unlawfully. He has placed handcuffs on the defendant and is in the process of pat frisking him. That is when he sees the drugs. Is there some other argument about inevitable discovery or independent source because it was maybe another officer could have come along and seen it in the car? Perhaps. That's not how it was seen for the first time. The state has a burden of establishing any exceptions, independent source, plain view, inevitable discovery. The state hasn't even argued those, so it can't have carried that. To talk about the Terry stop, Terry frisk, the case law, I think what we're talking about is there reasonable, articulable facts supporting the conclusion, not the defendant's a bad guy, not the defendant's done something violent in the past, not the defendant is a criminal, not the defendant is anything, but that the defendant is armed. There is nothing here the state could point to, has pointed to, that I think raises that in any meaningful way that you could think, yes, he is, there's a good reason to believe he has a gun or a knife or other weapon on his person right now. If the idea is because he has been in prison, that is reason to think he is armed. I think there is both I guess I would say a factual problem with that. I think that is factually not true. People that have been in prison are not likely armed all of the time. I think there is a significant constitutional problem that having paid your debt to society and flattened your sentence, you don't now have permanently a lessened privacy protection provided by the Fourth Amendment. So I think that Pat Frisk, if the state's even contending that anymore, I think there is not adequate reason to find articulable facts supporting the idea that he has a weapon on him that needs to be found. The final thing to go to the forfeiture, well, let me say just briefly, to go to the forfeiture, I think the state has again sort of heightened the problem with its argument, and it says, that the defense was raising the idea the officer didn't care. And that is absolutely true. The defense was raising the idea the officer is not doing following through. He's jumping to conclusions. Maybe he has reasons for jumping to conclusions. But that's a perfectly legitimate argument. And that is not at all rebutted, responded to, answered by proof, not just that Officer Marasigan started the forfeiture process. That's not the problem. The problem is the proof came in that the forfeiture process went through, resulted in this sort of quasi-judicial finding 10 months later, and that Mr. Flamini never filed a petition during that proceeding. That speaks in no way to whether Officer Marasigan was jumping to conclusions, didn't care. It's a completely different issue. So I don't think it is relevant to that question. And fundamentally, in my reply brief, I tried to make the analogy that if in a case the defense at trial to rape was consent, we would never think it okay for the state to put in proof that the defendant exercised his right to remain silent after being arrested and did not say that he thought that he had consent. This is substantive use of the fact that Mr. Flamini did not come forward over that 10-month period with an explanation for where the money came from being used as an indication of his guilt.
Very briefly before you sit down, if I may, on the suppression issue, are you arguing that the state has waived its reliance on the search incident to arrest theory? He seemed to think that you weren't necessarily arguing that, and I just wanted to hear it from you.
I think it's, yes, I think it's inappropriate for the state to be changing its theories. In my brief, I cited Lawrence versus Stanford, general rule that questions not raised in the trial court will not be entertained on appeal. So the idea that this was a search incident to arrest, when it wasn't argued before, I think the court can simply say it's too late to make that argument.
What about the footnote in Johnson versus State? So the Supreme Court in 2001, 2002, in a Brady case, the Supreme Court has a footnote addressing exactly this issue. So the defendant in that case had said that the state was changing arguments on appeal. The Supreme Court said, no, you're arguing different arguments from the facts that are in the record. You're not raising wholly new arguments without support in the record. If that's the standard Johnson was applying, is that any different than what's being applied here? And your friend on the other side says he's applying just new arguments to facts that are already in the record.
Well, this may answer or maybe doesn't answer. I mean, that ties into the problem with this, that here the argument the state is making on appeal is different, and because it's different, there are no facts about it below.
Okay, that's fair enough. Okay.
Thank you. We'll rest on our brief.
Thank you, counsel.
Thank you. Okay, here in about another 30 seconds or so, I will call it the next case, but if anybody needs to take a leave, you're welcome to do so before we call it the next case.
Versus Billie Jean Sliger.
Good afternoon, Your Honors. May it please the Court. My name is Mitch Raines with the Public Defender's Office, and I'm here today on behalf of Mr. Billie Jean Sliger. At this point, I'd like to reserve 4 minutes for rebuttal.
All right, thank you.
Thank you. Your Honors, I've raised 5 issues on appeal, but for purposes of argument today, I'm only going to try and address 3. But if the Court has any questions about the sufficiency of the evidence as it relates to count 3, or the trial court's imposition of a 74-year total effective sentence, I'm happy to try and address those as well. The first issue that I would like to address, though, is actually the third issue I raised in the brief, and that was the trial court erred in not requiring the state to make an election as to count 2. So this deals with the unanimity doctrine, and I would just note for the court that the state in its brief has said, quote, "The modified unanimity instruction was specifically created to protect a defendant's right to a unanimous jury verdict in situations where the proof spoke to more instances of a type of abuse than there were counts in the indictment." And I agree with that statement, but I think that there's also more there's more to the modified instruction than just that. And generally, what the instruction is meant to address is when we have a young child who is testifying about sexual abuse that's generally protracted and extensive, so many instances over a long period of time, and because of their youth or maybe a mental incapacitation, something of that nature, they're not able to testify with enough specificity that would generally allow the state to say this count relates to this specific act. In this case, we don't really have that kind of setup. HP was 15 at the time of trial, and by all accounts in the record, she was a good witness. She was articulate, able to explain herself, but there were really only 3 instances of digital penetration that were testified to, which related to both count 1 and count 2. So what we wind up here with is a modified instruction given on count 2 when there are just 2 instances of penetration at issue. During the course of testimony with HP on direct, the state really only elicited kind of generic information and didn't attempt to hone any of the specifics about or anything time-related really that would have allowed for an election as to really any of the 3 instances of penetration.
So could an election have been made on the record as it was?
There was an election made to count 1.
Count 1, right, but I understand you to say there are 2 other instances that could apply to count 2. And
Yes.
what I'm asking is there a sufficient basis in the record to be able to make an election between the remaining 2?
I believe so. I believe the state could have simply did the opposite of what it did for count 1 and elected the last instance of penetration. I think that would have been a sufficient election.
Say that one more time.
So in count 1, the state elected the first instance of penetration. I think as to count 2, they could have easily made an election that was just the opposite of that. So the last instance of penetration. I think that would have been enough specificity to say that's the count that we're going to elect for count 2. I understand that that's not ideal under any circumstances, but I do think that it probably would have remedied this issue.
If they could have done that, and if the proof would have supported a conviction under count 2 for that last incident, doesn't the procedure as it actually occurred here, didn't that actually benefit the defendant? Because it's requiring the state at that point to prove both instances beyond a reasonable doubt.
Well, I think in this record, because the testimony was essentially so generic as to the circumstances surrounding all 3 of them, there probably would have been a sufficiency argument if there had been an election to count 2 and it was based on just what's in the record. But ultimately, because there's no direct evidence, it's all he said, she said, and a credibility determination, I still think that it was kind of amorphous enough to say that there was enough presented to make an election for count 2. And again, the issue that I have with giving a modified instruction as to count 2 is that it doesn't meet the original parameters or the original situation for what that modified instruction was designed to cover. Again, it's typically seen, and that's because it's meant to address instances where there are many, many instances.
When you say typically, what do you mean by that? You talking about Qualls itself, Qualls progeny? Like, what do we mean by typically?
I think that, yes, Qualls itself points out that modified instruction is going to be warranted where there are many instances of conduct.
Because there were a lot in Qualls.
And typically, Your Honor, in the cases that support application of a modified instruction, they mirror the situation in Qualls, where there are a lot.
By its terms, limited to instances where you have 50 to 100 incidents.
I don't think that it necessarily has to be pinned to a direct number, right? That if it's more than this, then you get the instruction. If it's not, then you don't. But I think looking at the specifics of this situation, where we have an individual, the alleged victim, testifying, who is able to testify as to specific instances, but isn't asked anything that would elicit any kind of testimony that would really pin down when these three different courses of conduct occurred, that is not what a modified instruction is meant to govern. It's meant to allow the state to put on proof when they have essentially a victim making a claim who cannot articulate those things necessary to say count one applies to this, count two applies to this.
So you're arguing really two things there, that there aren't enough incidents here to invoke the modified instruction under clause.
Mm-hmm.
And also the state could have put on more proof to clarify this maybe a little bit with the witness. Am I hearing you?
I don't think that I would separate it out into two different blocks. I don't think that one needs to be a numerical value applied to the number of instances of conduct at issue. I think it's more a totality of the circumstances that needs to be looked at. So if a trial court is going to give a modified instruction, was the defendant able to testify? Well, one, did the victim testify to substantial amounts of conduct? Did it encompass a long period of time? Is it a young child who's incapable of really pinning down when these events happened, or is it someone who can testify to some kind of specificity? And in this case, I think looking at the totality, we just don't have that situation that would have warranted the modified instruction. We have HP, who's 15 at the time of trial. She was 11, I believe, 11 or 12 at the time of the alleged conduct. The indictment spans 2 years. There's testimony from HP and the mother that would narrow that down to about 1.5 years. But then there's only 3 instances of conduct. So all of that, looking at all of that, I don't think that warrants a modified instruction. And kind of on the same token, but perhaps on a different level, is that the state could have elicited more information from HP that would have narrowed down when did these 3 instances occur. Were you in school? Was it somebody's birthday? Was it hot outside? Any of those things. And really all we have is the lights were on the first time that there was inappropriate conduct, but no penetration. And then there were 3 instances of penetration that occurred when the lights were off. And then the state elected, for count 1, the first instance of sexual penetration for that offense. And then the trial court gave a modified instruction for the other 2, instances as to count 2.
I mean, can you help me again? Now to go back to the question I asked earlier. How does the state make an election between the last 2? Is it just, as you said, as I thought I understood you to say, was I'll just pick the last one? How does the jury know what the last one is? How does the state make an election here?
I will say that is not the best way to make an election.
Is it possible?
Absolutely. I think that it might have been possible, just in full candor to the court. I didn't research or brief out that specific issue of whether or not selecting just the last instance would have been sufficient. But
how would the jury have known what the last instance was?
Because it's tied then to a temporal element, right? So it's either, so it would have, based on the information in the record, it would have occurred sometime in late 2019 to 2020 before they moved out, something along those lines.
So with the second instance, right? I mean, typically when we're talking about elections, what we're trying to do is sometimes tie them to events. So we're talking about the inappropriate conduct at the birthday party. We're talking about here when they were over at the swimming pool over the summer. How do you possibly distinguish the second and third times here? I mean, because everything you're saying could be applied to both, right?
Well, I agree with you, Your Honor, and like I said, I do not think that it is the best way to do it.
Is there any way to do it?
If this court is going to,
I'm not suggesting I'm going to do anything.
I'm just saying, if this court were to
it?
find that it isn't sufficient to say that the last instance of contact is insufficient to make an election, I would agree with that, and I think then it's an issue of whether or not there was any evidence to support count 2.
But you don't argue that.
I don't, Your Honor, because when I was writing my brief and looking into this issue, I didn't see anything that essentially said that couldn't have happened, right? That temporal link wouldn't have been strong enough to say that it is insufficient to make an election based on that.
Okay, fair enough.
So it's,
I'm
yeah.
sorry.
No, go ahead.
I wanted to ask you about this footnote in Qualls.
Mhm.
Footnote 14, the Supreme Court says that they're reserving the question of how to apply its holding in cases of specific and generic testimony. Is that what we're dealing with here? And how should we view this case in light of the Supreme Court saying specifically that they weren't addressing that issue in Qualls?
I think that the framework that is still laid out in Qualls is sufficient for this court to address the problem here. Again, backing or circling back to the original purpose behind creating the modified unanimity instruction. It's one, to preserve a defendant's right to unanimous verdict rendered by a jury, but it's also to address these kind of amorphous situations where you have alleged conduct that's being put forward by a victim who doesn't have the capability to really espouse specifics about that.
How do we know that she did or didn't, though? Because you're saying she's 15, she should have.
Mm-hmm.
Another person could say, yeah, she's 15 talking about something that happened when she was 11.
Well,
Three incidents over a 2-year period. How is she supposed to differentiate those?
She gave plenty of other specifics about other things that happened during that same time, right? When they moved into the house, where her grandfather would stay while he was there, the family members that were present, a new stepfather coming into the picture, a new baby, she gave plenty of detail and discussion about the disclosure that she made to a cousin in North Carolina, something like that. So, but I do think that the record bears out that she was very capable of explaining what she said happened to her, but there just wasn't an effort made by the state to elicit that information. Moving to the second issue, if the court has no further questions about that. The second issue is really the first issue that I raised in the brief, and that's the trial court erred when it interrupted the jury's deliberative process to impose a deadline. The state, just to start with, has, in its response brief, claimed that this issue has been waived. And in my reply brief, I think I pretty thoroughly addressed that the state has actually waived its waiver argument. I know that's a tongue twister in the making, but and I've cited to several instances or several cases in my reply brief that essentially hold that what's good for the goose is what's good for the gander. So when we're looking to the waiver doctrine, when it really applies is when a party has a first opportunity to raise an issue or to address an issue. And here we have Mr. Sliger filing a motion for new trial that very clearly raises the trial court's interference with the jury's deliberation, coming in at 4:05, 4:15, something like that, telling the jury you, one, have to reach a unanimous decision, and you, two, have to do it by 5 o'clock, or we're coming back after the weekend on Monday at 9 o'clock.
Okay, here's my question.
Yes, Your Honor.
So, in your mind, is it the fact that it was at 4 o'clock as opposed to, say, 3 o'clock? In your mind, if the judge had called everybody in at 3 o'clock and said, okay, if you all haven't reached a decision by 5 o'clock, we'll adjourn for the weekend?
I certainly think that I would have a weaker argument had the trial court made that instruction earlier.
What about 3:30? Would you have the same argument? I mean, I'm just trying to figure out what's so magic about 4 o'clock.
I think that
if I did it at 10 till, maybe. I said, if you can't decide this in the next 10 minutes, we're adjourning for the weekend.
Yeah.
But, I mean, I'm just trying to figure out why you think 4 o'clock is problematic.
I mean, the whole argument depends upon it being only an hour left of adjournment, right? Because as the presiding judge says here, I mean, if it were stated in the morning, as courts typically do, hey, we're going to be here until 5 today, and then we'll adjourn for the weekend. We're under no rush, no big issue. You would have no issue with that, my guess is. So is it clearly just a matter of timing when the trial court decides to let the jury know?
I think I would, first of all, I would still have an issue even if it were made in the morning. I fully admit to this court, though, it would be a very weak argument.
I mean,
I probably would make it if I had something stronger to do.
And the trial court can control the deliberations, right? And so the trial court could adjourn at 5, and it could tell the jury that it was adjourning at 5.
That's correct.
Okay.
But the trial court is not supposed to take any actions, if I can answer this question. I see I'm out of time. The trial court is not supposed to take any steps or any actions that are going to place a coercive effect on the jury. And here, looking at the totality, we clearly have a coercive act. It's not just that it happened at 4:15 or something like that. We have, looking at the trial court statements, I don't have it here in front of me, but it essentially called the jury in. It told the jury, we are going to adjourn at 5 o'clock, less than an hour, and you have to render a unanimous decision. If you haven't rendered a unanimous decision by 5 o'clock, then we're going to wait after the weekend and come back on Monday at 9 o'clock. It then asked if the jury was making progress. It said that it was. And then it said, do you think that we're close? Again, after just being told it has to render a unanimous verdict, and it has to do so in less than an hour when it had already been out for 5 hours, I think that that puts a coercive pressure on the jury that otherwise wouldn't have been there if the judge had simply asked if they were close, or if it had waited until 5 o'clock. It did. After being told that it had to render a unanimous decision, which is just inaccurate under the law, and also it had to do so by 5 o'clock.
What did you say just there? What's not adequate under the law? You don't have to reach a unanimous verdict?
That's
Maybe I
correct, Your Honor.
misunderstood.
In Tennessee, it comes up mostly in a dynamite charge, but State v. Kersey is probably the seminal case on that. It makes clear that a hung jury is a proper
okay.
response. That's what I mean.
I mean,
Not that it has to, not 11 to 1, and that's fine. But what I mean by that is a hung jury is an appropriate response. So telling the jury, you have to reach a unanimous decision, and you have to do so by 5. It's just coercive. I'll reserve the remainder of my time for rebuttal. Thank you.
General?
Good afternoon, Your Honors. May it please the Court. Garrett Ward on behalf of the State of Tennessee in the matter of State versus Billie Jean Sliger. Your Honors, I will devote my time before this Court to the election issue and the sort of courtroom schedule communication issue, and I'll rest on my briefs for the remainder of the issues in the case. And if this Court obviously has any questions about them, I'm happy to discuss them. Starting with the election issue, I take the way this issue seems to have evolved at argument is not that, and I'm at the risk of oversimplifying, my friend on the other side, I take his argument to be not that anything in Qual specifically says that this was wrong, but that this is a little atypical. And I think that's interesting, and it gives away rather a lot. And maybe this makes sense because under the plain language of Qualls, which the state does quote in its brief, I point the Court both to Qualls itself and Perry, which is a recent case dealing with the modified unanimity instruction that this Court has discussed. What Qualls demands, what Qualls says, is we employ this modified unanimity instruction. Court should employ this modified unanimity instruction in cases where a victim is unable to, or simply where the sort of the evidence at trial isn't such that the state can make an election. And Your Honors, that seems to fairly plainly be the case from the evidence that's adduced at trial. I want to note briefly, there's nothing in the record that says the state has made some decision to not pull out the facts that would allow it to make an election. That there's nothing that suggests the state had some strategy of not getting specific testimony from the minor victim here in some sort of gambit to just rely on the, frankly, more onerous modified unanimity instruction. What it seems happen is what happens in many of these child sex abuse cases, that you're dealing with a young person, in this case a 15-year-old, who is testifying in 2023 about events that happened in 2018, maybe early 2019, late 2017, so 4 years ago. And she's not just testifying about any event, she's testifying likely about the most traumatic thing that has ever happened to her and will ever happen to her. And like many child witnesses in these circumstances, her testimony is not, especially when it comes to sort of when exactly did this abuse occur, it's not all that specific. And it's this exact circumstance that the Tennessee Supreme Court in Qualls said we should use this modified unanimity instruction because that will allow the state to present its case even in situations where the victim's testimony is not as specific as the state would frankly prefer it to, as the state would like it to be at trial. I would guess that the prosecutor would have been quite frankly pretty pleased if the victim had been able to give, laser specific testimony about each of the 3 instances of penetration.
The instruction that was given, General, it's pretty much the verbatim instruction
Yes, Your Honor.
that we see in the TPI. Did it explicitly exclude the proof that was presented as to support count 1?
I believe so, Your Honor, and obviously this court will be able to check my recollection of the record against the record itself. My recollection is that the trial court and the state, sort of when the election is happening, that there certainly was able to be a specific election as to count 1, because for count 1, the victim was able to come up with sort of a specific fact. Only once did this happen when the lights were on, so we can make that election. The instruction, as I recall it, does essentially tell the jury, look to sort of the other instances of abuse that she testified to in rendering your verdict under the modified unanimity instruction.
What did the Supreme Court mean in footnote 14 of Qualls when we're talking about the combination of specific and generic evidence? Where were they headed on that?
I think where they're headed is at the risk of sounding a little flip, they're headed precisely nowhere on it. They're saying nothing about it. They're waiting for another day to determine how exactly it should be analyzed, how exactly the modified unanimity instruction should be analyzed in a case where like this one, some counts have some counts have specific evidence, and some counts have more generic, such that the modified unanimity instruction is used. I'll note I did not interpret Mr. Raines' brief as laying out some black letter law that the state couldn't use this instruction in a case where there is sort of mixed evidence. So the footnote is there because in Qualls we only have generic evidence, but the footnote isn't really, as I read it, making any comment about whether about the place for the instruction in
Well, I
mixed
guess that's
cases.
why I was asking if the modified instruction here excluded count 1, because I'm just trying to think, are there implications to using the instruction in a mixed case such as this that maybe we're not thinking about? And that's why I was curious about the instruction that was given in this case.
So the instruction that's given in this case, from my best recollection, does try to does cabin the sort of modified unanimity consideration to not the proof of count 1. I hesitate to make too much supposition about hypotheticals for fear that perhaps, like the court, I'm not thinking about some of these implications as well. But there's nothing in Qualls that really hints that there are these implications. There's just this footnote, and I don't think that footnote can be read really in any way to say, look, we need to be really careful about the modified unanimity instruction in mixed cases. I read the footnote as just saying this is a legal question that we save for another day. And from my recollection of cases employing the modified unanimity instruction since Qualls, and there aren't all that many for a variety of reasons. I'm not aware of a case that presents exactly with this situation, and perhaps this is the day the Supreme Court's reserving its judgment for. But at least right now before this court, I think we're well within what the Supreme Court has sort of said the modified unanimity instruction should be reserved for.
Could there have been an election made in this case?
I'll say to
Your
the
friend says that the state could have elected the last incident.
I'll say to the court, I'd feel a lot more uncomfortable making my argument if the state's election this was just the last time this happened, for many of the reasons that Your Honor noted during my friend on the other side's argument. That the problem is we don't have any facts to tell the jury which one was the last time it happened. So maybe 7 of the jurors think it's, incident 1, and 5 of the jurors think it's incident 2, and that's what election is supposed to guard against, is sort of the idea that the jurors might be thinking of the different instances. We wouldn't have anything to identify the last one other than saying it's the last one, but the jury would sort of be free to decide which of or would be sort of forced to suppose as to which of these 2 incidents was the last one, because there would be nothing in the record that would suggest it. I don't think we could just sort of throw out there, it was the last time it happened, with no fact that would allow us to identify some incident as perhaps being being the last one. And frankly, from my read of the record, I don't think, not only would the last one not work, I don't see anything else in this record that would have worked. The state gets an election in count 1 because there is this one unique fact. Although it's seems relatively mundane, it is at least a differentiating fact that we have for count 1. This time the lights were on. None of the others the lights were on. Other than that, the description of the 3 instances of penetration, they're largely exactly the same. I struggle in looking at this record. I really struggle to pull anything that would allow the state to make an effective election. And indeed, if the lights hadn't been on when count 1 occurred, we would likely be looking at a modified unanimity instruction for count 1 and 2, but there was that specific fact here for count 1. I want to address, my friend on the other side pointed to, for some other instances, for some facts. The minor victim in this case was able to be specific. To some extent that's true. There is I'll say a fairly unique aggravated sexual battery charge in this case. I think it's a little surprise that charge was able to be specifically testified to. I think it's a little surprise that the minor victim in this case could recall some specific things about the time in her life when she was 11 or 12. What I think is unsurprising is that she had a little trouble recalling exactly what happened during, or exactly what was going on, what specific event was happening. Was it a Monday? Was it a Tuesday? Was it during the summer? I think it's unsurprising that she really struggled to recall those sort of events as it pertains to the 3 counts of rape of a child. And that's precisely why the Tennessee Supreme Court adopted and blessed the use of the modified unanimity instruction in clauses for cases like this one. Turning to what I'll call the sort of courtroom schedule communication. Your Honors, this issue has been waived because what happened here is when the trial court made this communication, the defendant and his counsel stood there and said nothing. They stood idly by and are now saying that was error. Well, the waiver doctrine, Your Honors, principally exists to prevent a party from standing idly by while an error occurs and then complaining about it on appeal. And that's precisely what we have here.
He's saying, and this is a theme, I guess, today, that you've waived this argument on appeal, or the state has, I should say.
Certainly, Your Honor.
Not you, General. What do you make of that argument?
There are a couple points on that, Your Honor. There are a pretty limited number of instances in Tennessee law that you can point to and say the state has outrightly sort of waived a waiver argument. My friend points to a couple in his brief, and they're pretty notable cases that are almost unique to their facts. One is Abdurrahman. As this court is likely aware, there's not really another case like Abdurrahman in Tennessee jurisprudence. Abdurrahman doesn't really, where there's an agreement about maybe post-conviction jurisdiction made below. I'm not sure that's really of much use to us here. Perhaps the case my friend relies on a little more is the Watkins case. And what we have there is a sort of a specific agreement by the state at trial, I believe, as to sentencing range, if my recollection of the case is correct. that then the state is maybe trying to step back from on appeal. And you know, in that circumstance, the court said, okay, state, you can't really pull it both ways there, but what's present in both of those cases and isn't present here is this sort of explicit agreement.
It's an estoppel argument. Largely,
Sure,
isn't it? And
sure.
So I think what you're arguing here is that you're not estopped by
Right.
the agreement you made in the trial court.
In cases that are less estoppel and are more just waived, waiver tend to arise in the post-conviction context, where waiver is almost, although it uses the same noun as sort of a term of art, waiver in the post-conviction context is slightly different, and has a really severe set of implications than we have here on direct appeal. I'm not aware of any case from this court or the Tennessee Supreme Court suggesting that the state waives the issue of whether or not something is on plain error versus plenary review on appeal based on what it says at the motion for new trial stage. And that it'd be a little odd if there were a case that said that, because the verbiage of plain error review from Adkison and any of the cases applying it largely discuss this court in the Tennessee Supreme Court examining what happened in the court below, and specifically contemplate the existence of a clear record, which are both things that aren't really present at the motion for new trial stage. I think that explains, at least to some extent, why none of the cases that my friend has pointed to, or any case I'm aware, has said that plain error review may only be employed if the state asks for it at the motion for new trial stage.
So let's say you're right. Is there plain error on this issue?
Absolutely not, Your Honor. There's no, the defendant cannot meet all of the plain error requirements. I think principally, and where most plain error analyses will start, is there's not a breach of a clear and unequivocal rule of law here. I take my friend's argument to be analogizing what happened in this case to more alarming and concerning jury instructions that have been given in other cases where a court has sort of set a hard deadline on deliberations and told the jury, look, come to a decision by this time, or I'm declaring a mistrial. I'm throwing it out. I'm saying it's a hung jury, so you have 60 minutes to come to a decision, or all your hard work, this whole trial, this all goes away. Well, we didn't have that here. Or cases where the court says something that really tries to lean on the sort of holdout jurors, where the court inquires of the jury, where are you at? Are you close? And then says something that impresses on the holdout jurors, you guys, maybe better come in line. If we had something like that here, I'd be singing rather a different song. But we don't have an instruction, and I'll use instruction. It's not really even clear that what the court does here as an affirmative jury instruction. It seems in a lot of ways more like sort of an administrative communication about courtroom schedule, but that's largely I think a semantic point. We don't really have the court saying anything here that would cause a holdout juror to think that they had better get in line with the majority jurors. And there's nothing that would cause the jury to think that if they didn't come to a decision by a certain time, they wouldn't be able to continue to deliberate.
In fact, the court told them they could continue to deliberate. It would just occur after the weekend.
Precisely, Your Honor. The court does exactly the opposite of impose a hard deadline on this jury. It sets some parameters for what deliberation might look like. The court's not going to be open 24/7. It's going to close at some point, especially on a Friday afternoon. So it tells the jury, look, you guys are essentially, tells the jury, you're free to communicate with one another and deliberate as long as you would like, but, it might have to continue on to the next day of court, which is Monday morning in this case. So it doesn't tell the jury, look, you really have to come to a decision by a certain time. It tells the jury that it can continue to deliberate. It's free to deliberate on Monday morning if it so chooses. Nothing in the court's statement suggests that the court would be crossed by that, or that would in any way be improper. It's just the court telling the jury what deliberation is.
What do you make of Mr. Rain's argument, though, that the court was, I don't want to say intentionally, but kind of disregarding the prospect of a mistrial, saying you have to reach a unanimous verdict, and by the way, we're leaving in an hour?
I don't think a reasonable read of what the court says is is somehow communicating to the jury that it can't, sort of declare itself hopelessly deadlocked. I don't see anything like that in this instruction. If the jury does return a verdict, an acquittal or a guilty verdict, that verdict does have to be unanimous. The court doesn't, tell it you have to. The court doesn't, from my read of the record, say anything that would cause any juror to think that they couldn't declare themselves hung. And frankly, the prospect of a hung or deadlocked jury seems rather far afield just based on the very brief communication we have between the court and the foreman. Because fairly early on in this conversation, the court asks of the foreman sort of, how are you guys doing? And the foreman says, we're close to a verdict.
Can I take you off of, real quick, because I know your time's about up.
Certainly, Your
On
Honor.
the consecutive sentencing aspect, the state in its brief notes that the standard of review may be de novo. And that typically clues me into that the state believes there may be an issue with the trial court's findings in this case. Do you believe the trial court adequately identified the category upon which consecutive sentencing was appropriate? And if so, did it
appropriately identify and weigh aggravating circumstances?
So a couple of brief points on that, Your Honor. The trial court, when it is imposing consecutive sentencing, largely discusses deterrence as its basis for imposing consecutive sentencing, and that is less than ideal. So there is from that perspective.
I guess ultimately that's what I'm getting to. Should we remand, or why should we?
I don't believe a remand is necessary in this case, Your Honor, because although the court does discuss largely deterrence when it's talking about consecutive sentencing, it makes a lot of findings or I hesitate to say a lot, it makes several findings when it's discussing enhancement that do directly speak to the aggravating circumstances we have that would allow for imposition of consecutive sentencing in a case with multiple instances of sexual abuse against a child. That's an independent basis for imposing consecutive sentencing, as this court is well aware. If there are multiple convictions that involve sexual abuse of a child, which is undisputably true here, the sole inquiry at that point would be, is there the existence of aggravating circumstances? And the court, in its enhancement findings, does say on the record directly that the defendant abused a position of trust to commit this offense and something else. But if this court has no further questions, I'd ask you to affirm.
Mr. Raines?
Thank you, Your Honor. Well, I had my paper, but I've lost it. I'll first just start with the modified unanimity instruction again. So it's more than just there are the number of claimed instances of conduct outnumber the number of counts. And what Qualls goes back to, at least my reading of Qualls goes back to time and time again, is that it's a prolific amount, it's a proficient amount. It's hard to nail down any one particular instance as it relates to a specific count.
Does Qualls say prolific?
That may be my term. I'm not quoting there when I say.
Well, because I'm just looking at the Jones case, is this California case that Qualls basically adopted. And I noticed that Jones involved the child victim testifying to conduct of 3 instances. So there you have 3 instances of sexual abuse where they applied the unanimity instruction. And that was the case that Qualls chiefly relied upon in adopting that in Tennessee. So I just want to press a little bit. We're not necessarily talking about cases that have tens upon tens, if not hundreds of incidents. It could be a smaller number, could it not?
It could, Your Honor, but again, I think it's more the totality of the circumstances that when you look at them, was there an ability to elicit this particular information that would have specifically related or correlated to?
Was there on this record?
I don't believe so.
There was not an ability to articulate further as to the facts?
There was. There absolutely was. It's not in the record, but there was an opportunity to do that. Based on HP's testimony as to other events, where she's able to give specific detail about other instances outside of this conduct. I think
other sexual instances, or other instances like a family member moving in or someone being born? Or
it's mostly other instances outside of sexual conduct. There is testimony regarding count 3, about an incident that occurred in the living room where, again, that happens with more specificity or more detail.
The toothbrush incident.
That's correct, Your Honor.
That might clearly stand out in someone's mind.
Yes, Your Honor.
Given the unique nature of the offense there. But with what we're talking about here, isn't there just a qualitative difference between 3 things happening in a bedroom in the middle of the night versus a grandfather moving into the house, or some of the other examples that you've given?
I'm just going to respectfully disagree. I don't think so. I don't think dealing with a child of this age, especially at the time of trial, and dealing with the 3 instances. And I would also, Judge Hickson, like to point out, you raised the issue of what kind of instruction was given as it relates to count 2. First of all, as to count 1, the election, as the instructions were given, just relate to the first act of digital or vaginal penetration. So there's no correlation to whether the lights are on or the lights are off. And I believe HP actually testifies that the first time that there was maybe an attempted touching or something like that, that the lights were on, and then there were 3 instances of actual penetration that occurred while the lights were off. And then the second instruction, or for count 2, it just says, now the state has offered proof in this case in chief. Now the state has offered proof in its case in chief of more than one act allegedly committed by the defendant, which the state alleges constitutes an element of the offense of rape of a child as charged in count 2 in the indictment. To ensure a unanimous decision, you have to these instances basically have to be proved beyond a reasonable doubt. But there's nothing that narrows those down away from the specific election that occurred in count 1. Well, seeing that I'm out of time, I won't go into the other issues, but I would ask that this court vacate Mr. Sliger's convictions as requested in the briefing. I know there are different remedies for different issues, and essentially remand this case for a new trial. Thank you.
Thank you, Counsel.
Okay,
Yeah,
thank you,
thank you.
Counsel.
All right.
Are you all ready to proceed with the next one? You okay? Okay. All right, Madam Clerk, would you call up the next case then, please?
State of Tennessee versus Antonio Gipson.
So then people have to walk.
Good afternoon. May it please the court, Joshua Hedrick here on behalf of the appellant Antonio Gipson. If your honors please, I'd like to reserve.
And if you'll hang on just a second, I think we've got a few more people coming in, so let's just wait for just a moment. If you could, Mr. Hedrick.
It is, so far, Judge, it has been the longest I've been quiet my whole life. I'll take an effort at another minute or two.
If you're asking the court to comment on that statement, I'll decline.
I will gladly, actually.
Mr. Hedrick, I'll say that probably me too. So that's
That was a low one right down the middle.
Yeah. Speaking of sports analogies, I think the general needs the hat trick award for today. 3 arguments in one session.
I'll take whatever the court will give me.
Okay. All right.
Same here.
Okay. Madam Clerk, would you call that case one more time, please, just for the record?
State of Tennessee versus Antonio Gipson.
All right.
Thank you. Good afternoon, and may it please the court. My name is Joshua Hedrick on behalf of the appellant Antonio Gipson. I'd like to reserve 2 minutes of my time for rebuttal argument, please. Your honors, Antonio Gipson's conviction for second-degree murder should be reversed for 3 reasons. There are 3 reasons, as raised in the brief, are that first, it was error to exclude the prior threats made by the decedent in this case. Second, that it was error to exclude the evidence of the prior gun possession by the decedent where it was corroborative of the self-defense claim. And third, that the evidence was insufficient as a matter of law. I'd like to focus my attentions today on the first 2 issues and rely upon the brief for the sufficiency argument, although I'm happy to answer the court's question about that issue if there are any. I'd like to turn first, if I may, to the question about the prior threats made by the decedent. In this case, Mr. Gipson urges that it was error to exclude the testimony of Ms. Allison. I am going to say her name as DeSiniqua. I was not trial counsel, and I may be pronouncing her name wrong. If so, I apologize. But Ms. Allison was to testify about what, well, excuse me, at page 284, we see an exchange with the officer where we're talking about threats that were made by the decedent. And as we know about this case, essentially what happens in this case is that there is a difficulty. The decedent, Alex West, was a previous paramour of the lady who was dating Mr. Gipson. And there was some difficulty between them. An order of protection had gone down. Mr. West insisted on residing in the same apartment complex as Ms. Allison, despite the fact that he had previously been evicted from an apartment in that complex because of the order of protection and the threats, and simply just returned to a different apartment without telling anyone that he was going to be residing there. And we see in the record some threats at a McDonald's. He confronts Mr. Gipson and shows a picture on the phone and says, "Is this you?" About the picture of the gentleman sleeping on Ms. Gibson's sofa. So there's sort of a campaign by Mr. West. At one point, I think there's testimony that he claims that nobody tells me, in relation to the order of protection, nobody tells me where to go, nobody tells me where to be, I'm going to do as I please. And so when the question is asked to the officer at 284 about these prior threats, it is being offered not to prove the truth of the matter asserted, but to prove what was believed, right? What was in the mind of Mr. Gipson and what was in the mind of Ms. Allison at the time the fatal incident erupted. And so it doesn't matter if they're true. It doesn't matter if the threat is true, and it doesn't even matter if the people who related that threat were telling the truth. What matters is that at the moment that confrontation erupted in the parking lot, Mr. Gipson had a reason to think that Mr. West had threatened him. And therefore, his fear was a reasonable one, whether that's true or not. That is, if I communicate to a person, Jason says he will kill you when he sees you, that is sufficient to give you a reasonable fear of Jason, whether I'm being honest or not. The fact that I may be dishonest doesn't make your fear unreasonable.
So, Mr. Hedrick, help me with this, if you could, please.
Mm-hmm.
It is difficult for me to tell from the submissions what threats are at issue and through what witness the party sought the threats to come in through. Could you identify specifically for me, please, what the evidence was that should have come in, you contend, and through what witness that evidence should have arrived?
So I will agree with the court that the record is a little fuzzy on that. And Ms. Allison did testify.
Well, she did. And I want to get to that in a minute.
Yes.
Right now, I just want to identify what the threats are. Because,
So-
I mean, in fairness to the court,
Mhm.
I think, not to speak for my colleagues, but in fairness to me, I read the submission itself, and I'm trying to figure out what the threats actually are that were excluded, because as you say, it may matter, and I don't see that. So where do I see that? Do I see that in an offer of proof? Do I see it on the motion for new trial? Do I see it in an argument by counsel? Where do I see
That is a difficult question for me, Your Honor, because what I'm aimed at is at 285 in the record, and the court, I must tell the court that the content of the threat does not appear in the record. It does not appear in the testimony because the objection comes before that is said, and there is no offer of proof made by trial counsel. There should have been.
Okay, so no offer of proof contemporaneously, nothing on the motion for a new trial.
And so we cannot necessarily know for certain, but I'll urge the court that should give us some concern. It does
give me concern.
It creates a difficulty. It creates a difficulty for me as appellate counsel because there is no offer of proof. But it also creates a difficulty because it creates a difficulty for the case itself, because the trial court has ruled on a statement it has not heard, and that is a problem.
Well, except that we don't know what the statement was, Mr. Hedrick, and so that's what I'm trying to figure out.
And that's
how
where
do we begin to balance the effect on the verdict, harmless error? How do we begin to balance that? Is it then? Are we talking about the statements that the victim made to the girlfriend?
Yes.
Okay. Now, she testified at trial, and she testified, I think, to some threats that were made by the victim or that she heard.
You're correct.
How's that evidence then not, for lack of a better word, sufficient to cure whatever issue had happened previously?
So, I think that that's the closest we will ever come, respectfully, because there is no offer of proof. I think that's the closest we'll ever come to know what the detective likely would have said.
Does it matter what the detective would have testified to if the person that actually heard the threats is testifying about it at trial?
I think it does from a corroboration standpoint, in the sense that it is helpful. You know, you always have that gap between the incident happens, there's a shooting, some time goes by, and then the people testify at trial. It's always beneficial or helpful to be able to establish that what she's saying to you today, ladies and gentlemen, is the same thing she told the investigator at the scene or the day after, right? To say that this is not something that is just now coming up. This is something that she said in the moment at the time.
Okay, so
is helpful.
So the fact of the threat is known to the jury.
Mm-hmm.
Maybe somewhat of the substance of the threat is known to the jury. What you say the jury doesn't know is that the girlfriend at the time related to the investigating officer that the threats have been made.
That's right. And I think that is, to some extent, helpful and useful because this entire case is a question of credibility. The things that are resolved by the physical evidence are no one contests. No one contests that Mr. Gipson fired the shot that killed Mr. West. No one contests that Mr. West died from the gunshot. No one contests where it happened, when it happened, the venue. None of that. The only question is, was it self-defense? And that turns entirely on witness credibility under the facts of this particular case. So the jury is weighing the credibility of these competing stories, right? The story of either Ms. Velasquez, who essentially tells a story of a man who is accosted and shot while unarmed, versus the people who tell a story of an ongoing dispute that ends in two men with pistols, and one draws on the other and the other fires, and it's self-defense.
Was the girlfriend's credibility challenged for a failure to have not revealed the threats earlier?
Do you mean, I'm sorry, you mean Ms. Allison, the girlfriend, not Ms. Velasquez?
The girlfriend, yes. What I'm taking you to mean, and forgive me if I'm wrong, is that really it's kind of I'm making a prior consistent statement, and the prior consistent statement bolsters my credibility at trial. And so in my own mind then I'm questioning, was her credibility called into question at trial because she had not made a prior consistent statement?
So there was not a direct challenge to her credibility in that regard.
Okay.
I would push back on the idea that her credibility was not challenged in the general sense.
So why do we need corroboration about the fact of the threat?
Well, because the jury needs to know. I think the jury needs to know that this is something that was on the mind of these people. That this was something that was not just created from whole cloth or that came later. That this was something that was existing at the time.
Sure,
right?
but with a prior consistent statement, though, there has to be a challenge to it. It's not admissible just because you made a prior consistent statement.
That is fair. That is correct.
And so without the challenge to this particular piece of evidence, why do you need the officer then to corroborate the fact that she heard the victim make threats, or maybe even more properly, how's the trial court in error?
Well, in a perfect world, I'd like to be able to point to a specific part of that statement, Your Honor, but unfortunately, I can't. I can only complain that the trial court, in an ideal world, would have held its ruling until it heard the statement and then analyzed the statement in that way. But I cannot, I've gone as far with that as I can, Your Honor. On the other issue, because I see I'm about halfway there, that it was error to exclude the evidence of the prior gun possession by the decedent. There essentially two separate issues. And this issue about there was a video in which the decedent brandishes a weapon and demonstrates him carrying the weapon tucked in the front of his waistband, which just so happens to be the area that Mr. Gipson, in his testimony, testifies he saw Mr. West reaching for, and he saw Mr. West reaching for the front of his waistband with his hand in his pants while he was threatening him. And then Mr. Gipson said he believed that he had a gun, so he closed that distance in the hopes of being able to grab him if he tried to draw it. And then when he did that, saw the butt of the pistol coming out of the waistband, and that's why he shot Mr. West. So the trial court analyzed that in light of Frazier, which was a case where this court ruled that gun possession on a prior day was not relevant to prove that a defendant possessed a gun on a day in question. And that, respectfully, is the wrong analysis, because what we're talking about here is corroboration of the self-defense claim, which is really something that depends on State v. Ruan, which R-U-A-N-E. That's probably not how you say that. But State v. Ruan on 912 Southwest 2nd, 766 from this court in 95. Frazier, the Frazier case, which the trial court relies on, doesn't have anything to do with any of that. Frazier doesn't have anything to do with determining primary aggressor. It doesn't have anything to do with corroboration of a defendant's claim. And it was clear that trial counsel was advancing this as corroboration of the self-defense claim. At 178 in the record, trial counsel says this is admissible because I have a right to corroborate my self-defense claim. At page 421 in the record, trial counsel says that this is being offered as corroboration, of his story, being Mr. Gipson's story. At 499 in the record, trial counsel says the video corroborates the defense theory. In page 500, trial counsel says that it deals with the way Mr. West carries his gun, and again at 501 says this corroborates our theory of defense. This corroborates our self-defense theory. The government, in its brief, asserts that there's nothing particularly unique about carrying a gun in the front of your waistband, but that is an opinion that does not have a citation to this record.
Respectfully, I don't think that's what I took the argument to be. I think I took the argument to be that carrying the gun in the waistband under Ruan doesn't meet its second factor, and that is that it doesn't show first aggressor tendencies. So we're not talking about corroboration of self-defense. We're talking about corroboration that the victim had first aggressor tendencies. Mm-hmm. And I think the state's argument, as I read it, was the mere fact that he had a weapon on a previous occasion speaks nothing to the fact about whether he had first aggressor tendencies. So if that's the argument, if that is the argument, what's the best response to it?
So the Frazier court talks about it in terms of relevance, just analyzes it in terms of relevance, because in Frazier there was raised both a 404 argument and a relevance argument, and the Frazier court rejects the 404 argument because the mere fact of owning a gun is not a bad act and deals only in terms of relevance. In terms of this case, however, we're not talking about just proof that someone has a gun. We're talking about proof that someone has been sending videos of them brandishing a gun, which is a very different activity, right, than brandishing a weapon. And sending videos of yourself brandishing a weapon is a different activity than the mere possession or ownership of a gun, and indicates something very different to the jury, right? That if the jury sees a video of you pointing the gun at the camera and waving the gun around, is very different than simply telling the jury, Mr. Hedrick owns a pistol, right? That, I agree, that is not prior bad act evidence. It isn't first aggressor tendencies. But in this case, the trial court did not make an analysis about first aggressor tendencies. At no point, despite the litany of times when trial counsel said this is corroboration, at no point does the trial court address the question of, is it corroboration? The trial court simply says, Frazier says this is not relevant.
So the video shows the victim brandishing the firearm?
I saved the victim brandishing the firearm because that's how it is described in the record, and I'm about to have another similar problem with Your Honor, because you're going to, respectfully, going to ask me, if we can see an offer of proof that contains the video, and I'm going to say to the court, no. However, it does appear to be the parties in the record discuss it as a video of him brandishing the weapon for the camera, I think, and that's where I'm getting that phrase.
From the discussion. I mean,
it's from the discussion.
it's not otherwise in the record at all. I can't go to anywhere in the record and look to see.
It does not appear that the video was included in the record. It appears that there was a discussion there was a jury out hearing where the parties discussed the content of the video, and I think we can glean from that, and I can get you, it may have to wait for, during my rebuttal time, I can get you a citation if I have a minute to look through the
Help me with
record.
this, though. We had lunch with the students prior to, some of the students prior to coming in today, and one very astute student of the law raised questions about, hey, essentially, how important is it to preserve the appellate record? How do we do that? Query.
Mm-hmm.
If this issue here is subject to harmless error analysis,
Mm-hmm.
I think it may be, even assuming that there's error, and I don't think that there is, how do we begin to look to see what the impact of the error was on the jury's verdict if we can't see the video?
I think that is very difficult.
Okay.
And I think that all that can be done at that point is to look at the way the parties discuss the video and take that at face value and say, if this were a question of brandishing the firearm, that if this were a video of him brandishing the firearm, that's something the jury should have known. And I think that's what it ultimately comes down to, is that in a question of facts, in a question of whether they're right or wrong, the jury should have made the decision of what weight to give this video. What do we take from this video? And the difficulty is that Mr. Gipson is the one who is in prison because the jury didn't hear that. So in terms of a harmless error analysis, I would say that it should have been preserved as an offer of proof. It absolutely should have been included in this record, and it would have helped greatly. However, the person who suffers for that is Mr. Gipson, who is not directly responsible for that, and that creates a difficulty. Beyond that, I don't have much to say other than hopefully that stands to stick in the minds of litigants why this is important.
Very good. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court. Garrett Ward on behalf of the State of Tennessee in the matter of State versus Antonio Gipson. Your Honors, I will leave the sufficiency issue to my briefs unless this Court has questions about it, and I'll spend my time before this Court instead discussing the hearsay issue and the prior gun possession issue. Regarding the hearsay issue, Judge Greenholtz, during Mr. Hedrick's principal argument, you asked him to identify what threats were supposedly suppressed by the trial court. That was, frankly, a struggle I had to, based on this record, because we just don't know what the trial court suppressed. What it seems most likely the trial court suppressed are the same threats that Ms. Allison and Mr. Gipson later testified to. So I think my sort of initial position on this issue would be, to the extent we are the threats that were suppressed by the trial court, were those same threats that were then testified to by two other witnesses, that would render any potential error harmless, and to the extent there is some other body of threat that Investigator Booker could have testified to and was prevented from testifying about, this court can't really review that issue because, as Mr. Hedrick has noted, there was no offer of proof given or drawn from Investigator Booker when he was told not to testify about the threats that Ms. Allison had told him that Mr. West had made.
So your friend suggests, though, that its chief value was in corroborating the girlfriend's testimony.
Mhm.
So that the credibility of the parties was quintessentially at issue, with Ms. Velasquez testifying as to one version of the events, defendant testifying to another version of the events. That the girlfriend's credibility certainly was at issue and would have supported the defendant's version. Speak to me, if you could, please, about the value of the investigator's testimony about corroborating the girlfriend's version of events.
And I'm happy to do that, Your Honors. Before I sort of speak directly to its value, I want to note that when the trial court excludes this testimony from Investigator Booker, it directly says to defense counsel, obviously, if you want to later recall Investigator Booker to have him corroborate the testimony that Ms. Allison or Mr. Gipson may give, you may obviously do so. So to the extent there is some value the defendant has lost because he doesn't have this corroborative evidence from Investigator Booker, he's the one that has to bear that weight because he was explicitly given the chance to do that by the trial court and chose not to avail himself of it. But speaking more directly, Judge, to your inquiry about the value, I think I have two specific points on that. One is this case is a little more than just a loved one of Mr. West saying he was unarmed and was shot by Mr. Gipson versus Mr. Gipson and his loved one saying that's not what happened. There were, I believe, 3 unaffiliated witnesses who saw the argument, who, from this record, don't appear to have any bias in favor of Mr. West or in favor of Mr. Gipson, and they give their version of events as well, and their version of events is that Mr. Gipson was unarmed during this. So I think just the presence of not 1 but 3 unbiased witnesses who are testifying about this case removes it from sort of that black and white, one interested party says A, the other interested party says B scenario that we sometimes run into. If that's what we had here, there might be a little more value on Investigator Booker's testimony. But since that's not what we have, I suggest to the court whatever value his testimony may have had would be lessened. I think my second point would be many of these threats the jury directly saw, not just because Ms. Allison testified about them and Mr. Gipson testified about them. Some of them were present in text messages that were introduced as exhibits. So, when Ms. Allison gets up and testifies, oh, he texted me this sort of vaguely threatening statement, the jury knows she's not just making it up because they see some phone logs. So there's really, I think, the sort of additional sort of font of proof for at least some of these threats, and not all of them. There are some other threats testified to about by Mr. Gipson and Ms. Allison that don't appear in the text messages. But for at least some of them, the jury does get to see them, does get to see the threats themselves, and I think that only further lessens whatever value Investigator Booker's testimony may have had. So we have a situation where, yeah, he's maybe offering some corroborative proof of, he may have been able to offer some corroborative proof of what Ms. Allison said, but there's frankly better corroborative proof there. That's the text themselves and sort of black and white text message that the jury's able to read. But I maybe want to back up. I do think there's just a base issue here of whether or not the trial court acted properly in excluding them. Obviously, my position is that if there was an error, it is wholly harmless for the reasons I've just said. I'd also suggest the court just wasn't in error here. We have sort of a hearsay within hearsay issue where what the defendant wants to draw from Investigator Booker is what Ms. Allison told him that Mr. West told her. And when I believe it's in Mr. Gipson's brief, when he's discussing why this testimony is important, he says that this testimony is important so the jury can specifically hear the threats that Mr. West made. Well, what that really gives away is that, at least presenting it in the hearsay within hearsay, guys, we are concerned about the truth value of at least that first layer of hearsay. That concern isn't there when Ms. Allison directly testifies about the threats that are made to her, and Mr. Gipson directly testifies about the threats that he saw, which is likely why there was no hearsay objection when these threats came in not once but twice later at trial. So I'd suggest to the court that there wasn't error here in the first place in excluding the statement, but that even if there was, given the abundance of other proof about these threats and then the strong corroborative proof and the defendant's decision to not recall Investigator Booker, as the trial court gave him the clear opportunity to do that, for all of those reasons, this would be harmless. Turning now to the issue relating to the video of prior gun possession. Your Honors, we run into a similar problem here that we do in issue 1, in that we don't really know what this video is. I've never seen it. It's not in the record on appeal. There is some discussion of it in the record on appeal by Mr. Gipson's trial counsel. He describes it on page 499 and 500 of the trial transcript as being a video that shows Mr. West's MO of carrying a pistol in his crotch. That's, I think, about the best description of what this video is that this court is going to see in this record. It's described, in very brief terms at a few other places. I think 499, 500 is probably the best.
So there's one video, right?
I believe so, Your Honor.
There's one video. I thought that the description of the video was as you had described it, where it was simply a video of the victim carrying in his waistband a pistol or a handgun. Your friend suggested it was a little more than that, based upon his reading of the arguments of counsel. So how do you view your statement in light of counsel's arguments? I respectfully, to Mr. Hedrick, I didn't read the record in the same way. I saw, based on my read of the record, that largely what the video shows is him carrying this firearm in his waistband, and I think it makes sense that the video is chiefly described in that way by Mr. Gipson's trial counsel, because he's clear that the reason he wants to, at least to me it seems clear, the reason he wants to introduce this is to show that he was carrying a weapon in the same place in this video that Mr. Gipson says he was carrying a weapon on the day of the shooting. Mr. Gipson testifies that he's carrying a weapon in his waistband, so the video also shows him carrying a weapon in his waistband.
General, obviously the video should have been placed in the record.
Yes, Your Honor.
And it's obviously a problem to some extent, but given the reasoning that defense counsel wanted to use this in the trial court below, is it as big a problem in this case? He was trying to use the video to corroborate his client's claim and belief that the victim carried a weapon in his waistband. And everyone seems to agree in describing the video that basically that's what it shows.
So a couple of points on that, Your Honor, because I think there are sort of two things that are sometimes happening when it comes to what purpose this video is going to serve. Sometimes at trial below and on appeal now, when Mr. Gipson discusses the video, it's important because it shows the victim behaving as a first aggressor. And sometimes when we discuss the video, it's important because it just shows the victim carrying a firearm. I take Your Honor's question to be more directed to the latter of these. Yes. It's a problem. The biggest problem with that potential purpose of the video is the problem that this court identified in Frazier, that a video of a person, at least as far as I know, there was at the time the video was recorded, no restriction on Mr. Gipson carrying a firearm, that a video just showing a person carrying a firearm.
That's not what I'm hearing him say under that argument, though, and I'm sorry to interrupt.
Certainly.
I'm not hearing him to say, this was a bad guy, he's a first aggressor. Saying, I want to corroborate the fact that I thought he had a gun in his waistband.
So, Your Honor, if the defendant is seeking to introduce this for sort of corroboration purposes under the Ruan case, if he's not saying that the purpose of the video was to show that the victim was a first aggressor, he just loses. Because that's a requirement for this.
The case requires that. Right?
Yeah, it's a requirement for this specific sort of, I'll call Ruan like a special carve out for admissibility. That if you have evidence that speaks to first aggressor tendencies, you can get it in through Ruan's specific rubric. If Mr. Gipson is admitting that this video, and I believe he'd be probably wise to admit this, if he's admitting that the video has no tendency to show that the victim is behaving as a first aggressor, then he loses under Ruan because he is required to say that. If what he's saying is this more generally is relevant, then his problem is that he fails the basic relevancy test because this video is months old. I honestly can't tell the court how old the video is because I haven't seen it. I don't know if there's a time and date stamp. There's discussion of it being months old. This court recently said in Frazier that, you know, even a few days before an incident occurs, that it's just not relevant whether somebody was carrying a firearm. So there are two problems, and I don't believe it's possible to address either one in this case. From the description of the video, there seems to be no indication that there's first aggressor tendencies, and without that, he loses under Ruan. And if the argument is just he's carrying a firearm, then that's just not relevant based on the description of the video we have in this case and the discussion of its age. Perhaps, and this is why I allude at least to some degree in my brief, perhaps if there was some, you know, wildly distinctive way of carrying a firearm, maybe that Frazier problem would be ameliorated if there was some elaborate holster device that the video depicted and that the defendant was saying Mr. West was using on the day of the shooting. But that's not what we have. The video is, as best I can tell from the discussion of it in the record, months old. It shows nothing particularly remarkable, and nothing of the discussion of the video in the record suggests it speaks to first aggressor tendencies. So either under sort of classical relevancy grounds or the sort of special Ruan grounds, it doesn't meet either of these bars. So the trial court was well within its discretion to exclude it. If this court has further questions, I'm happy to answer them. Otherwise, I would ask that you affirm. Thank you, Your Honors.
Your Honors, please, I rise for two reasons. One is to clarify what I said about the video. On line 8 on page 500, the video is described as showing off the gun, which I have characterized to the court as brandishing the gun. And I want to just point that out because they're not exactly equivalent terms, but in the record it does say showing off the gun, which I still think is more than merely possessing, but maybe not quite as far. As far as the corroboration and the purpose, the difficulty that my friend is having is that we're thinking in terms of sometimes we argue one thing, sometimes it does the other thing, but the reality is it's doing both, right? This video is both corroborative of first aggressor tendencies in that it's being offered to argue they're showing off the gun, he has a first aggressor tendency, and also to corroborate what the defendant is saying in terms of his version of events as Judge Hickson was described. It's not doing either or, it is doing both. And the reason why that's important is because in Frazier, there was no discussion of corroboration. Corroboration makes it relevant because in this case, you have a defendant who says that man had a gun and it was in the middle of his waistband. And the other witnesses come forward and say, we didn't see a gun. And so this is offered to corroborate what he's saying by being able to tell the jury, well, when we downloaded Mr. West's phone, there was a video of him carrying a gun in exactly that way. And that corroborates, that makes more likely what Mr. Gipson is telling us might be true. Because he had no way to know that video is there. It came from Mr. West's phone. So, ladies and gentlemen of the jury, it is also corroborating what he's telling you. It's making what he's telling you more likely, which is a very different analysis than the plain Frazier analysis. And I have gone over, so I apologize. Thank you, Your Honors.
Thank you. Thank you.
All right. Thank you, Councilman. Are you okay? Okay. All right. I want to thank all the counsel that we've had
today with us. That's completed our oral argument part. I think all the lawyers, Mr. General Ward has been here for all three of the cases, as well as Mr. Hedrick from this case, and Mr. Raines as